Hey y'all, favorite family law attorney Bonnie Roden with Roden Law Group in Brevard County, Florida. In this video, which is the 8th in a series of 10, we're covering some of the most overlooked but important topics in equitable distribution. What happens with pets, it's very important, and collectibles, Social Security and pensions, alimony overlap. We're going to talk about credit score risks, and we're going to talk about personal injury awards and how and if they get divided. So let's jump first to the fun one, which is unusual assets. So pets are one of my favorite. I also ask these questions during interviews when I'm doing will packages. You know, we include pets because in Florida, a pet is considered chattel, which is a belonging, even though many feel that these are pets that are members of the family. So they're property under Florida law. In the case of Bennett v. Bennett, the Supreme Court in Florida ruled that pet custody is not enforceable, that instead one party or the other gets ownership, and the court will not divide ownership. However, two parties can divide ownership of a pet, a dog, a cat, a bird, a turtle, snakes, whatever you have. You can become joint owners of that property, that animal. For collectibles and like Hummels or Swarovski or I don't know, Fabergé eggs, collectibles and artwork. So if you have a Picasso hanging in your house or a Klimt or something else, courts will follow a case that is Duncan v. Duncan. And that case requires that those items be properly valuated by an appraiser, so an appropriate appraiser. Mediation can help when there are sentimental items or high value items. It's really hard if you only own one Picasso, who's going to get the Picasso at the end of the day. If the court has to decide, if you go to the judge is going to simply put it on a balance sheet with its proper valuation and assign it to one party or the other and make sure the other side is compensated with an equal amount of assets on their side of the balance sheet. All right, so let's talk about Social Security and pensions and how they factor into property division. Social Security is Social Security is federal, and that is not divided in a Florida divorce. But a dependent spouse may qualify for benefits if you've been married for 10 years or more. Pensions, however, are divisible. So in the case of Boyett, the Supreme Court of Florida clarified for legals that only the marital portion of a pension can be divided. What does that mean? So that means if you've worked for Coca-Cola for 25 years and only 15 of those years were you married to your spouse, then the court will assign an equitable distribution of only the 15 years during the marriage, because anything that you accumulated in retirement benefit is considered a marital asset to be divided. If you do end up dividing some sort of a pension, there is a document called a qualified domestic relations order, which is also referred to as a QDRO, that is used to instruct the manager, the financial manager that handles the pension or the 401k, to instruct them on how to divide. So one thing, little tip to remember is when you're dividing a pension, you want to make sure that your document includes a reference to the marital portion plus cost of living increases, sometimes called COLAs. So that's a good thing to include, because if the pension will increase over time, then you want to have your proportionate part of that increase. Okay, so does equitable distribution have anything to do with alimony? Yes. The more that each spouse receives in equitable distribution, the more that is going to affect an award of alimony or spousal support. So if you have a $5 million estate and each party is walking away with $2.5 million, then it may be that asset base can create enough income for the spouse who is not earning in order to meet their need to finance going forward in their life. If it isn't going to produce enough, which is normally 3 to 4% is what the court will assign, 3 to 4% of the total. So if you're walking away with $1 million, 3 to 4% is what the court will assign to you in income. That also crosses over into child support calculations, but that's for another day. Alimony is not income for income tax purposes at this time. However, alimony is considered income when calculating child support. Okay, there's case Lutgert v. Lutgert. There was a really large property award, and it reduced the alimony eligibility of the weaker earning spouse. And also, you want to avoid double counting. What is considered equitable by the court may reduce or eliminate your spousal support qualification. All right, so what do we need to know about marital debts and credit scores? If your spouse is assigned the debt and it's in your name alone or together, the creditors don't care. There is a case right on point. It's Gonzalez v. Gonzalez, and one spouse was still liable for credit card debt assigned to the other party. So it was debt in her name, and it was assigned to be paid by him, and she still was held on the hook. And showing the creditor your divorce decree doesn't have any effect on the creditor because the creditor is not part of the case. The creditor is not under the jurisdiction of the family court in Florida, and so therefore they don't have to acknowledge it or follow it. So it's really important that when you're talking about debt, that if you have joint accounts or accounts in your name that are going to be assigned to the other side, you want to refinance those debts or just plain pay them off. And that's critical to get that done before final judgment. That's, again, a whole nother topic about the enforceability of equitable distribution terms in a final judgment. You want to have as much of it done prior to final judgment as you can. All right, so the last thing in this particular video, what about personal injury cases? I have people who call and ask for advice that they're getting ready to get a huge settlement for a case that's been going on for 4 years, and they want to get divorced really fast before the check gets cut. And so they would be, they're usually happy to know that under Florida law, and especially from the case Moss v. Moss, the court explained that damages for lost wages are marital. So if you were out of work for 2 of those 4 years and that's worth $40,000 a year, that $80,000 would be considered marital. However, the pain and suffering, the medical, and all of that is likely separate and non-marital. If your settlement documents in your case for your personal injury case, it's structured and it's itemized, the courts can easily divide it. If it's not well written by the personal injury case attorney, it could be argued in court. The key here is clarity in the documentation and then clarity also in the timing of these items. Medical, if there are medical bills in a personal injury case, the medical companies want to be reimbursed. If your insurance covers it, the insurance company is going to want to be reimbursed. If you had to pay co-payments and those were paid out of marital funds, then if I were on the other side, I would expect that those co-payments, the equivalent amount would be put back into the marital pot from the settlement in order to reimburse the marriage for spending those co-payments. So for this video, just remember, divorce doesn't have to mean that your financial life is completely uncertain. You have a good family law lawyer who can guide you through the process, write down your questions, and either ask for a meeting or send an email with your questions together and ask the attorney to address those with some legal responses. And if we can help in any way, if you're in our general area in East Central Florida, you can always give us a call or visit our website. Thanks so much. Watch for videos 9 and 10 coming. Bye.